National Liberty Alliance was founded in 2013. The purpose of NLA is to provide an online national venue where the people can organize, communicate, and learn the science of government by consent, and learn how you can organize your neighborhood or connect with them if one already exists. As the swamp is drained and power removed from the deep state, a vacuum will occur. And if we the people do not educate ourselves and fill these positions of authority, our servants will, and it will only be a matter of time before we find ourselves back under tyranny again. Go to nationallibertyalliance.org and learn the science of government by consent and connect with your neighbors. Thomas Jefferson said, "An enlightened citizenry is indispensable for the proper functioning of a republic. Self-government is not possible unless the citizens are educated sufficiently to enable them to exercise oversight. It is therefore imperative that the nation see to it that a suitable education be provided for all its citizens. Therefore, if a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be." The solution, Thomas Jefferson said, was to educate and inform the whole mass of the people. They are the only sure reliance for the preservation of our liberty. NLA provides the only peaceful and lawful solution to save our republic, and it will require a grassroots commitment to about 15,000 people to take it back. Thomas Jefferson said, "We in America do not have government by the majority. We have government by the majority who participate." If we don't take back our courts, America will be lost forever. In 2002, we the people held a Truth in Taxation hearing and invited the federal government. It was broadcast over C-SPAN in Washington, D.C., and the government failed to attend, and we concluded that our courts of law are closed. In 2004, we the people held a conference to restore constitutional order, again inviting the government, and they failed to come, and was broadcast over C-SPAN. In 2008, U.S. Supreme Court denied answering the question concerning the right of redress of grievances. In 2009, we the people elected delegates for the Third Continental Congress from 48 states, which met in St. Charles, Illinois, and produced the Articles of Freedom. In 2010, delegates served the Articles of Freedom upon the United States Supreme Court, the United States Legislature, and the President of the United States, all 50 governors, and all legislative bodies of the states, and we were met with silence. In 2015, we the people formed the common law grand jury and served a writ quo wanto and many writ mandamuses, all unanswered. In 2016, we the people, via the common law grand jury, filed an extraordinary action with over 100 documents. We the people were again met with silence. On December 14, 2016, we the people opened an extraordinary common law court of record action in the Federal District Court for the Northern District of New York, demanding a redress of grievances, serving dozens of papers upon the United States Supreme Court, U.S. Congress, U.S. Senate, and many others. 2017, President Trump started draining the swamp and dismantling the deep state. August 17, 2019, we the people filed a decision and orders and a declaration of restoration of the law of the land and a demand for the resignations of those who are of a mind to resist or suffer indictments for fraud on the court, conspiracy, felonies, and or treasons. April 6, 2020, we the people filed the following paper reviewing the record with a final order to obey the law and honor your oath, our last warning before our final judgment that we will render after the storm. Paper we filed in the United States District Court for the Northern District of New York. It's an extraordinary action, and this particular paper is for the reviewing the record and a final order prior to our final decision. And again, it's addressed against the United States Supreme Court, the federal judiciary, the Senate, the House of Representatives, and the American Bar Association. And the administrator of the court is the United States Grand Jury. That's the Tribunal of and for the people. This was copied to President Trump and Attorney General William Barr. We've been copying all of our papers the past 3 years or so. Prior to Barr, we were filing it with Sessions. But this one is now to Barr, and it is dated April 6th, 2020. As the storm is upon us. Comes now the above entitled Court of Record to review the record. This is our closing statement, after which the court is adjourned until after the draining of the swamp, and the enemies of liberty are brought to justice, at which time we will make an assessment, remove the olive branch, and summarily determine the facts and reiterate the matter as law and justice require. Meanwhile, we will continue to file joinders, habeas corpuses, and indictments of federal and state judges that ignore due process. We, the people, have declared that prudence indeed will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience has shown that mankind are more disposed to suffer while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, reveals a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such tyrannical gods, and to provide new gods for their future security. The findings of facts. The United States Supreme Court and the federal judiciary, orchestrated by the insidious Bar Association, have covertly abrogated the law of the land via the Rules Enabling Act of 1934. The American Bar Association is the second top-ranking special interest lobbying group, contributing more than $47 million to the members of the 116th Congress during the 2019 and 2020 election cycle in return for their support when voting, also known as a bribe. Lobbying is a repugnant process by which cunning, ambitious, and unprincipled men enable themselves to subvert the power of the people and to usurp to themselves the reins of Congress and the federal courts through their filthy money. The history of the American Bar Association is a history of repeated destruction of our constitutional republic, all having in direct object the establishment of an absolute tyranny over these states and the people via repugnant civil law. Civil law, and Roman civil law are convertible phrases, meaning the same system of jurisprudence. That rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the laws of nature and from international law. Federal Rule 2's civil law is repugnant to the Constitution. It is not law. Federal Rule 2 is subversion against the United States of America. We have in the past and hereunto do also nullify Federal Rule 2 and proceed under the rules of common law. 16th American jurisprudence states that the general misconception is that any statute passed by legislators bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land, and any statute to be valid must be in agreement. How much more by rule? It is impossible for both the Constitution and a law violating it to be valid, one must prevail. This is distinctly stated as follows. The general rule is that an unconstitutional statute, though having the form and the name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionally dates from the time of its enactment, and not merely from the date of the decision superseding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed. Such a statute leaves the question that it purports to settle, just as it would had the statute not been enacted. Since an unconstitutional law is void, the general principle follows that it imposes no duties, it confers no rights, it creates no office, and it bestows no power or authority on anyone. It affords no protection and justifies no acts performed under it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existent valid law. Indeed, insofar as a statute or rule runs counter to the fundamental law of the land, it is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. And by the way, rules are not law. They have no authority or power over anything to put forward any kind of a law that is unconstitutional. The Rules Enabling Act of 1934 gave the United States Supreme Court the power to make rules of procedure and evidence for federal courts, as long as it does not violate subsection 2072B, which states, "Such rules shall not abridge, enlarge, or modify any substantive right. All laws in conflict with such rules shall be of no further force or effect after such rules have taken effect." The United States Supreme Court ignored said restriction, ignored their oath, and under the civil law teachings of the American Bar Association, wrote and enforced in our courts the Rules Enabling Act in violation of 18 U.S.C. subsection 2A, which states, "Whoever commits an offense against the United States, or aids, abets, counsels, commands, induces, or procures its commission is punishable as a principle. Whoever willfully causes an act to be done, which if directly performed by him or another would be an offense against the United States, is punishable as a principle," and in violation of 18 U.S.C. subsection 2385, which states advocating the overthrow of a government. And thereby the teaching of the American Bar Association, the United States Supreme Court, and its judiciary all conspired to and did unlawfully abrogate equity. They abrogated natural law. They abrogated due process. They abrogated our Constitution. They abrogated our habeas corpus. They concealed common law courts of record. They replaced unalienable rights with civil rights. They intimidate, stack, and taint grand juries. They intimidate, stack, and taint petit juries. And they incarcerated thousands of people without due process. We the people are endowed by our Creator with certain unalienable rights, and to secure these rights we vested judicial power in one Supreme Court and in 94 inferior federal district courts. We the people permit the judges of both the Supreme and the inferior courts to hold their offices during good behavior. We would like to remind you that your powers derive from the consent of we the people, and that when any form of government becomes destructive of these ends, it is the right of the people to alter and to institute new servants, who will adjudicate in light of the law of the land that we ordained, that we believed would seem most likely to affect our safety and happiness, and not what traitorous American Bar Association judges believe. We are not interested in what judges believe. We demand your unyielding obedience to American jurisprudence and natural law. We told you these things via our founding documents that you took an oath to support, defend, and protect. But we, the people, being lulled to sleep, have been betrayed. The sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people from whom the government emanated, and they may change it at their discretion. Sovereignty, then, in this country abides with the constituary and not with the agent. This remark is true both in reference to the federal and state governments. The doctrine of sovereign immunity is one of common law immunities and defenses that are available to the sovereign. In the United States, sovereignty resides in the people. Congress cannot invoke the sovereign power of the people to override the will of the people. It will be admitted on all hands that with the exception of the powers granted to the states and the federal governments through the Constitution, the people of the several states are unconditionally sovereign within their respective states. We are appalled by the arrogance and malevolence of so many federal judges that abhor justice, preferring the repugnant status quo, thereby selling their souls for their portion of 30 pieces of silver. We, the people, have an indubitable, unalienable, and indefeasible right to reform or change our government whenever it is found adverse or inadequate to the purpose of its institution. These maleficent judges believe that they are to privately interpret the law and not adhere to American jurisprudence. They believe that they are above the law, that they answer to no one, and that they have sovereign immunity. Let this communique serve notice to all federal district judges that you have no such immunity when you act under the color of law and outside your authority that we vested you with. It is we, the people alone, by the blessings of God, that have sovereign immunity from statutes, codes, regulation, and your de facto civil law. Be forewarned that this organic, unified United States common law grand jury, also known as the Tribunal of this court of record, has decided the removal of all lawless judges via indictments is the appropriate action when being denied due process, which, within any lawful society, is the most precious of all unalienable rights, without which there is no redress, leaving us with only our second unalienable right to exercise our liberty to redress our grievances. Judges are creatures of the law and are bound to obey it. If judges break the law, they can be removed for bad behavior, prosecuted, and sued for damages. They are duty-bound to obey the law. If judges fail to defend the Constitution when it is brought before them, they war against it and must be removed and possibly tried for treason. We do not see the United States Supreme Court defending the law of the land. There is a common law maxim which states, for every injury there must be a remedy. We, the people, will have our remedy. And since most of Congress is guilty of subversion, fraud, and RICO, they are incapable of impeaching you. Therefore, we, the people, will perform such an extraordinary action via indictments, which is our unalienable right, as we await the imminent removal of what lies beneath the swamp. Article 3, Section 1 is clear and states, the judicial powers of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges both of the Supreme and the inferior court shall hold their offices during good behavior. So take judicial notice. Silence can only be equated with fraud, where there is a legal or moral duty to speak, or where an inquiry left unanswered would be intentionally misleading. At least since 1938, the de facto United States Supreme Court and its subservient federal judiciary adjudicate without lawful authority, but by rule under Roman law or civil law in jurisdictions unknown. Under federal law, if a court is without authority, its judgment and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a recovery sought, even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. The natural liberty of man is to be free from any superior power on earth, and not to be under the will or legislative authority of man, but only to have the law of nature for his rule, not the rules of a court. The decisions of a superior court may only be challenged in a court of appeal. The decisions of an inferior court are subject to collateral attack. In other words, in a superior court one may sue an inferior court directly, rather than resort to appeal to an appellate court. Decisions of a court of record may not be appealed. It is binding on all other courts. However, no statutory or constitutional court, whether it be an appellate or a Supreme Court, can second-guess the judgments of a court of record. The judgments of this de jure court of record, whose jurisdiction is final, is as conclusive on all the world as the judgment of the United States Supreme Court would be. It is as conclusive on the United States Supreme Court as it is on other courts. It puts an end to inquiry concerning the facts by deciding it. Government is a creature of law with a clipped sovereignty sufficient only to exercise their vested powers. We, the people, the children of nature's God, receiving our sovereign authority and unalienable rights to create an indissoluble government by consent whose duty is to secure our rights, not deprive our rights. The unalienable right of the sovereign people to self-governance was ordained by God, established in the Declaration of Independence, and ordained by we the people, who are the authority of all law via the Constitution. Any servant who resists these truths wars against the Constitution, the governor of the universe, and the people. The people owe the state nothing, and are under no obligation that would require the people to seek leave from any servant who has no jurisdiction or authority over them. We are not subjects of the state, but the masters thereof. The people of this state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. His, that is God, judges, that is the juries, are the mirror by which the king's image, that is righteousness, is reflected. A consequence of this prerogative is the legal ubiquity of the king. His Majesty God, in the eye of the law, is always present in all his courts. Though he cannot personally distribute justice, his judges are the mirror by which the king's image is reflected. Nature's God is the sovereign governor of the universe, the creator of all things, whose jurisdiction is eternal, even to the very souls of men. In the beginning, he vested man with authority over his creation and commanded that he subdue those who are subtle and would force us into bondage. In 1776, we the people, via America's foundational documents, the Declaration of Independence, covenanted with nature's God, acknowledging his jurisdiction and laws, and thereby received his blessings of liberty, being freedom from all law but his. Any government that is its own judge of and determines authoritatively for the people what are its own powers over the people is an absolute government, of course. It has all the powers that it chooses to exercise. There is no other, or at least no more accurate, a definition of despotism than this. For more than 800 years, that is since the Magna Carta in 1215, there has been no clearer principle of English or American constitutional law than that, in criminal cases, it is not only the right and the duty of the juries to judge what are the facts, what is the law, and what was the moral intent of the accused, but that it is also their unalienable right and their primary and paramount duty to judge of the justice of the law, and to hold all laws invalid that are, in their opinion, unjust or oppressive, and all persons guiltless in violating or resisting the execution of such laws. Unless such be the right and the duty of jurors, it is plain that instead of the juries being a palladium of liberty, a barrier against the tyranny and oppression of the government, they are really mere tools in its hands for carrying into execution any injustice and oppression it may desire to have executed. Treason consists of two elements: adhering to the enemy and rendering him aid and comfort. Evidence. We have filed and served 35 and counting habeas corpuses listed herein, and federal district judges concealed and carried away said judicial proceedings that we deposited with the clerk in violation of 18 U.S.C. subsection 1519 and 18 U.S.C. subsection 2071, leaving many people falsely imprisoned, children stolen from their parents, and the elderly and their estates are stolen from their children. We have filed and served 55 and counting amicus curiaes listed herein, demanding due process or dismissal of these unlawful procedures on behalf of the people losing their homes via non-judicial foreclosures, as these village, towns, city, and county judges conceal and carry away said judicial proceedings that we deposited with the clerk of the court in violation of 18 U.S.C. subsection 1519 and 18 U.S.C. subsection 2071. As they ignore the move to federal court and cause in collusion with federal court Justice Lawrence E. Kahn, leaving their victims in jurisdictions unknown. We have filed and served 36 and counting amicus curiaes listed herein on behalf of the people in various cases who have been denied due process and suffered losses, as again towns and village and city and county judges concealed and carried away said judicial proceedings that we deposited with the clerk of the court in violation of 18 U.S.C. subsection 1519 and 18 U.S.C. subsection 2071, and then they ignored the move to the federal court for cause in collusion with federal court Judge Lawrence E. Kahn, leaving their victims in jurisdictions unknown. We have filed and served 38 papers with 25 evidentiary documents on the United States Supreme Court, U.S. Congress, all 50 governors and state legislators in this extraordinary case concerning subversion and conspiracy by enemies, both foreign and domestic, and we have been met with silence. Judges have no right to decline the exercise of jurisdiction when it is given, than to usurp that which is not given. The one or the other would be treason to the Constitution. The following list of papers have been filed in the above said court and can also be found at nationallibertyalliance.org/action-against-judiciary. The consistent, uniform, tyrannical actions by judges from village, towns, cities, counties, states, and the federal courts, all acting in an orchestrated fashion, is in itself evidence of conspiracy, concealment, fraud, denial of due process of law, and the carrying away of the people to jurisdictions unknown. Simply put, wars against the Constitution. How can a court claim to be just if it deprives the people of their property or condemns without being heard? The United States Supreme Court has ruled and has reaffirmed the principles that justice must satisfy the appearance of justice, whereas federal judges' audacious denial of due process and unapologetic maintenance of status quo is self-evidence of courts of injustice. Between 2015 and 2016, We, the Unified United States Common Law Grand Jury, wrote many writs of informations and filed them with all 94 federal district courts, total of 16. On December 14, 2016, we the people filed a redress of grievances, opening a court of record, a common law court, filing a total of 13 papers. On August 17, 2019, in the same court, we filed a declaration for the restoration of the law of the land, a total of 9 papers, and 22 memorandums. We have filed into the court evidence over 25 documents. We've also filed over 36 amicus curiae for refusing due process and moved these cases into this federal district court for cause, violation of due process. We have filed over 35 habeas corpuses. We have filed 55 non-judicial foreclosures and moved them into federal court for cause. We have filed an indictment against Judge Lawrence E. Kahn, who tried to seize control of this court on numerous occasions. We have filed indictments, 33 of them, against federal judges for denial of habeas corpus, conspiracy, and felony rescue. We have filed 42 indictments against state judges for denial of due process, conspiracy, and felony rescue. We have filed a murder conspiracy indictment for the murder of Lavoy Finnegan against 36 individuals. The Tribunal orders the United States Supreme Court, the United States House of Representatives, the United States Senate, and the federal judiciary, they are to honor their oath and to support and defend the Constitution for the United States of America by their actions or resign immediately, or we will remove you via indictment for warring against the Constitution. Any judge who does not comply with his oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. The Tribunal orders the American Bar Association to cease the teachings of civil law practice in place of law and equity. It is so ordered. Albany, New York, dated April 6, 2020. Signed, Grand Jury Foreman, Common Law Tribunal.